So let's talk about how a lawyer approaches a case and the mentality and mindset that you need to bring when you're analyzing a legal problem. So there's a number of different schools of thought around what the best legal solution is to figuring out or cracking down on a problem. One that's quite popular is I.R.A.C, identify, research, analyze, conclude. That's a pretty popular one, but I never actually found it sat well with me. A very experienced barrister told me a particular methodology that I'd like to teach to you, which has been so helpful in allowing me to get on top of law and how to do it. The first thing that'll happen when you're a lawyer is you'll be super overwhelmed. People will bring you a matter you wouldn't possibly be able to understand, and you have to figure it out. The first thing you should do is make a chronology. And what a chronology is it's a timeline of what happened when. If it's a contract case, when did we enter the contract? When did we have the pre-contractual discussions? When did we exchange the value? Did we exchange the value? And I have found that the chronology will be the basis of everything you do. It's really a powerful tool. You use it in divorce cases. You'll use it in criminal matters. If you're trying to establish a timeline to say you couldn't have been there because this, and this happened, a chronology is always a really useful tool. So that's kind of the first thing I do. The second thing I do is called the Dramatis Personae. A Dramatis Personae is a who's who at the zoo. So it's a list of people, and what I'll do is their relationships to one another. So I'll literally write out on a piece of paper, my client is here, this is their mother, this is their father, this is the person they did a deal with, this happened to that. And by having this interconnected web, it enables you to get on top of the factual matters, because you're gonna have to figure out the factual matters before you move to the legal ones. So don't be overwhelmed. First thing you do is you do those things, a Dramatis Personae and a chronology. And there's tons of resources on how to do it. Whenever you get a legal problem and you've got the factual circumstances in front of you, you can attack it using these 4 steps. The first is called standing, or who am I? Standing is the right to bring an action to court. Not everyone will have standing in all matters. There's usually, you need to be connected with the matter in a meaningful way. You have to have some dog in the hunt. You can't just show up to court for random matters and be like, hi, I want to throw my hat in. It's about defining whether you have standing. Usually if a client's come to you, they have standing in some capacity, but sometimes they don't, and you just nip it on the butt. So who am I? Number 2, what do I want? This is a great question. A lot of people don't know, and it will be your job to educate them as to what the potential remedies available for their situation are. So under contract, we have so many different remedies. One of them is specific performance, i.e. do what you said you would do. If I sold you a piece of land and I'm not going to give it to you, do what you said you would do. They may not want that. They might want to just get out of the contract. They might want damages. They might want something else. What do I want is a really important question, because you need to understand what your client actually is seeking, and you need to make them available as to what the choices are. You need to convey to them that you can seek this thing, seek that thing. There's all these options available to you, but it sounds to me like you're really looking for this particular thing. So it sounds to me in a divorce matter like what you actually really care about is the house and having the stability of the house. You don't really care about the risky assets in the superannuation fund. You don't care about the risky assets in the corporation. You really care about the house, or you don't care about those things. You care about seeing your children this often, and these are your rights. So what do I want? And this will be very difficult, because you will need to dig when you deal with someone as to what they're actually here for. Sometimes it's pretty simple. I don't want to go to jail, or I want that jerk to pay. He hit my car, it's cost me 20 grand, I want 20 grand. Figuring that out, it's more complex. And all of these questions slowly get more complicated than else. The third is, why can I have it? Why can I have it is a fantastic question. And what it's actually asking is, where in the law can I have the remedy that you have said I can have in the second part? So for example, where in the law does it say that I can get specific performance in this type of matter? What's the legal framework? Is it common law? Is it statute? Is it an equitable principle or a doctrine? Is it reliance upon a particular idea? Where in the law, in the body of the law, do you have the power to get me what I want? What court do I need to go to get it? Do I need to go to the federal circuit court? Do I need to go to a state-based court? Do I need to appeal it up? Do I need to keep it in a tribunal? What is the legal landscape? And that's really where most lawyers live. Your job as a lawyer is to be able to answer that question. You can have it because, you cannot have it because. And you need to be able to articulate in plain English, or whatever language you speak, the reason you can have it is this, and the reason you can't have it is that. So that's a really important distinction that I don't think a lot of people make. And the fourth is, why should I have it? The advocacy. Convince me, if I'm the court or the tribunal, to use the power that I have in the step before to give you the remedy you had in the step before that, because it affects you because of the first step. Now, this is persuasion. The law says you can have this specific performance, but the reason you really deserve it is because unconscionable conduct by the other party. It could be because the law says you're entitled to be acquitted, but the reason we're really going to acquit you is because of these factors that come forward in the case. These are these matters that are so important that we need to refer to. And what I found paradoxically is that a lot of people become lawyers because they're pretty good at this step. They're the kind of people who are quite charming and urbane, and they can convince their friend, if I feel like Thai food and you feel like Indian, we're going to go get Thai food because I'm going to convince you. Or I want to see the Batman movie, you want to see Sense and Sensibility, well, we're seeing Batman. And that's a really good skill set, the ability to sell, persuade, and influence. But it's actually not as important as step 3, which is the ability to understand what can and can't be granted. I believe strongly that a lot of people misguidedly enter the law because they are obsessed with or want to kind of understand this particular area. And it's important, and it's really important, but it's not the thing that makes you a good lawyer. Your ability to answer 3 is, but 4 is kind of a sort of a different skill set. But it's very important. And it's very important to be able to persuade a magistrate, a judge, or the person you're trying to convince, even in a negotiation. If you're trying to convince them that I will take this all the way and I'm not scared of you, then you need to be able to persuade them of that. And that's sort of the advocacy side of things. So modality of dealing with a problem I have used since it was taught to me. It is certainly not my own invention. It was a very experienced barrister whose name escapes me at the moment, but he's brilliant. And that's how I've dealt with legal problems. I literally will break them down into those 4 steps, and I will go through them to figure out what the remedy is, how I can help my client. Does my client even have a right to a remedy using that? So one of the things that is so important for younger lawyers is to find something like that. Now, you don't need to take this framework. You don't need to use it. And, you may have your own framework that's even better than this. But if you don't have a framework and you want to work in litigation, give some serious consideration to the idea of developing the capacity and the ability that when you have a case, the first thing you do is you deal with the Dramatis Personae, the chronology, and answering those 4 questions. And if you do that in law school, if you do that in practice, you're going to be a really good lawyer, because you're going to be able to answer all of the questions that the judge is going to ask, your client's going to ask, and really opposing counsel is going to ask. Follow me for more content.